Welcome, and thank you for joining us on Level Up Law today. We're here at South Carolina Legal Services. We are leveling up your legal knowledge on the different areas of law that we handle. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I will be the host of the webinar today. And I'm joined by our producer, Kenneth Elliott, from our IT department here at Legal Services. Today, we are joined by Attorney Arthur Hayes from our Rock Hill office. He will be sharing information on how to get your landlord to make repairs. So if you're wondering how to handle that particular situation, stay tuned for some very helpful information. The webcast will be recorded and will be posted on our YouTube channel for later viewing later this week. That's at South Carolina Legal Services on YouTube, and also the slides that Arthur will be using will be posted along with that recording. Now remember, this is not legal advice today, but just general information for the public. You should always consult with an attorney for any specific legal issues that you have. And at the end of the presentation, we'll provide information on how to apply for free legal assistance at South Carolina Legal Services, and also how to access our information and resources. During the webcast today, you'll be in listen-only mode, but do be sure to put questions in the question box. We'd love to answer those for you, and as time allows, Arthur will provide some general information to answer those questions. Again, thanks everyone so much for joining us. And Arthur, let's get started.
Thanks, Susie. So, as she said, my name's Arthur Hayes, and I am going to talk about how to get your landlord to make repairs. And I want to go ahead and give you the answers. This isn't a pop quiz, so I want to go ahead and let you know ahead of time what we're going to be talking about. So first of all, I want to talk about what rights you have as a tenant, talk about kind of the law, the legal foundation for why you can demand repairs. Next, I want to talk about the legal requirements you have before you can access them, because there are some expectations on your part before you can make those demands. Thirdly, the options you have. And again, I want to go ahead and lay all the cards on the table. Your options are taking your landlord to court or breaking your lease and moving out. Then the process, like after we go through what the options are, I want to talk about specifically what you do to go through those processes and actually get the results that you're, hopefully get the results that you're looking for. And then I want to talk about your last resort. So I'll get into that. I'll get into that at the end. I'll go into more detail. So first of all, when we talk about rights as a tenant, we have to come from the South Carolina Landlord Tenant Act. That's a law specific to South Carolina that outlines the relationship and outlines all the obligations and all the rights that both landlords and tenants have. So who does this apply to? When we have the Landlord Tenant Act, obviously landlords and tenants, but what is a tenant? A tenant, the obvious option are the people who sign contracts with property managers to rent out, say, an apartment or a house or something like that. But a tenant can also be a sibling that has moved in with you. A tenant can be a former boyfriend or girlfriend who hasn't moved out yet. A tenant is anyone who has an agreement with the person who owns or runs the property to stay there. And so when it comes to that, what's a landlord? So, you know, the obvious one is the landlords are the people who accept rent checks, but the landlord can be anyone who is authorized to accept rent on behalf of the property owner. So the property owner themselves can be the landlord. You could have a property manager, a big company in town that handles yours and 100 other properties, or the property manager can be just a person that the landlord or property owner assigns to kind of run things. So lastly, when we get into rental agreements, when you think of a lease, when you think of a rental agreement, you think of a contract, a signed sheet of paper that talks about, you know, the pet policy and what you have to do for insurance, things like that. But a rental agreement doesn't have to be written. It can also be oral. And a rental agreement can just be just an understanding that you're allowed to live there. And there are such things as leases with $0 a month payments. So there can be an agreement where someone allows you to just couch surf. Someone says, hey, you can stay on my couch for 6 weeks until you're able to get your own place. That counts as a rental agreement. As long as a tenant has exclusive rights to use a space. So as long as you are the one staying on the couch and he doesn't offer that couch to everybody who needs it, as long as you have the right to stay on that couch every night, that is a rental agreement. So that's pretty broad. You know, that can take in those three things, like how those definitions work, can encompass a very broad range of living arrangements. So who does it not apply to then? What are the kind of people that are excluded? So even if there is an agreement to stay in a place and even stay in a place exclusively, it generally does not, the Landlord-Tenant Act generally does not apply to hotels, motels, or inns. And so there are fringe cases where, you know, is this place a hotel if I've been staying here for 6 months and I pay once a month rather than, so there are times where a place can call itself an inn or a motel, but those are always very specific to the facts of that situation. So next would be religious, medical, mental health, or educational facilities. So the Landlord-Tenant Act does not cover, for instance, college dorms, or if you are in a like addiction rehab inpatient facility and you're staying there for 2 months, even if you have a room and no one else can sleep in that room, it still is not covered by the Landlord-Tenant Act. And lastly, temporary, transient, or emergency housing. So these are places that are very temporary. You're not, even if the agreement is only for one night, those are not covered by the Landlord-Tenant Act either. So if that is who the law applies to, and those are the circumstances that the law applies to, what does the law actually say then? What are your rights as a tenant? And there are a lot of rights and a lot of obligations, but for purposes of this presentation, when we talk about getting your landlord to make repairs, I want to focus just on two of them. First of all, a landlord shall make all repairs to do whatever is reasonably necessary to put and keep the premises in a fit and habitable condition. You can tell that's straight from the statute because no one talks like that. So basically, a landlord has an obligation to repair the property however it needs to be repaired, whatever is reasonably necessary to keep the place fit and habitable. So what's reasonably necessary would be like if the if the wallpaper is peeling, that may, if it's just a little spot in the top corner, that may not be reasonably necessary to make it fit and habitable. But if it's the entire wall coming down, or if it's something else, then that may make it reasonably necessary to repair it at that point. So the landlord has an obligation to make those repairs. And a tenant can hold the landlord accountable for not making repairs after making the landlord aware of the problem and giving them a chance to fix it. That's not straight from the statute, that's kind of a summary, but that's basically, these two summarize what your rights are as a tenant. A landlord has to keep a property in a fit and habitable condition, and if they do not, you as a tenant can hold them accountable for it after making them aware and giving them a chance to fix it. So before, as I mentioned earlier, you have two options. You can take your landlord to court, or you can break your lease and move out. But before you even choose an option, you have to follow the legal requirements. So first requirement is what we call notice. That's a legal term, but basically it just means making the landlord aware of the situation. And the second one is time. After you make the landlord aware of the situation, you have to give them a certain amount of time as an opportunity to fix whatever the problem is. So with notice, you have to make your landlord aware of the problem and tell them, you'll either terminate the lease or take them to court if the problem isn't fixed in a certain amount of time. So you can't hold the landlord accountable for a problem that they don't know about. If you have something that isn't working and you never bring it to the landlord's attention, you will not be able to use one of the options presented later. The landlord has to know about the problem, and you have to it's your responsibility to make them aware. It's not their responsibility to come poking around to see if anything's broken. It's going to be on you for the most part. And that doesn't include like public spaces, like for instance, if you live in an apartment building, this doesn't apply to like the stairwell or open spaces like that. This applies to just the space you live in, just the space you have control over. So this notice can be written or oral. So you can make your landlord aware of the problem by simply telling them next time you see them. But I recommend in every interaction with your landlord, always get it in writing. Writing is always preferable. And not only that, but we always recommend that you get a writing that has the date on it and that maybe even is signed to just show that there's no disputing that the landlord was aware of this because they signed for it on this date. So after the landlord's made aware of the problem, and preferably using a written notice, after that you have to wait a certain amount of time. And you have to, you mention the amount of time in the notice, and you have to stick to that, whatever you say in the notice. So if you say, I'm going to give you 30 days to fix it, then you are binding yourself to wait 30 days to see if they do anything about it. So there are a couple different options for how long you wait depending on the nature of the repair problem. If the problem seriously affects, if the problem seriously affects health and safety, repairs must be completed within 14 days. So things that seriously affect health and safety, like if there is a nail sticking out of the doorway that you can snag your elbow on, if there's a broken stair, if there's black mold, if there are things that are genuinely unsafe or unhealthy about the property, you can give them at least 14 days to finish repairing it. So it doesn't matter if on the 13th day they start, but it's going to take a couple days. They do not come within the deadline if that's the case. The repairs have to be completed. You have to wait for 14 days and for the repairs to be completed by then. Now, if the problem seriously affects the condition of the property, the repairs must be started in 14 days. So if there's like the roof is sagging, or there's a leak, or pipes dripping, or things like that, then those don't always directly affect health or safety, but those do damage the property. And the longer they stay a problem, the more the property is going to get damaged. But in this case, if you tell them about that repair problem, then the repair needs to be started in at least 14 days. So when it affects health and safety, it needs to be completed within 14 days. If it affects the condition of property, it must be started in 14 days. And so for questions like appliances, or it's always going to be very specific to your situation. So there's a million different ways that things can be broken or need maintenance in any kind of rental, whether it be a house, manufactured home, or like a unit like an apartment. There are a million different things that can go wrong. But if it affects the way, like how you're able to live your life, so if like the toilet is not working, or your oven is not working, the stove isn't working, the sink isn't working, things like that, because those affect your day-to-day life, your eating, your hygiene, things like that, those would be considered health and safety. And if it's things that you don't necessarily rely on, like I said earlier, if the wallpaper is coming down in the corner or something, then that would be affects the condition of the property. And the third option is neither. If it's something that that doesn't affect your health and doesn't affect the condition of the property, or doesn't do those things yet, you just have to give them a reasonable amount of time in the notice, and then wait that reasonable amount of time. So a rule of thumb for this, if the condition doesn't seriously affect your health or safety or the condition of the property, the rule of thumb is 30 days. And just depending on how serious it is, if it's right on the edge between Whether or not it seriously affects health and safety, then you may be able to shorten that time, but all of these are just very specific to your circumstances. So after you satisfy these legal requirements, after you have given your landlord notice, preferably in writing, and after you have waited the appropriate amount of time, you can choose one of those options. So let's go through them. Option 1, taking your landlord to court. And I want to start with, this is always an option. I'm going to go through in a little bit and talk about when option 2 is not always an option, but just for right now, you can always take your landlord to court. And what's the benefit? Why would you do that? The benefits are, and these come from the statute, what you can do, what you can get from your landlord in these circumstances is, the first one's called injunctive relief. And that's basically the court telling the landlord to do something. An injunction is when the court commands somebody to do something. So injunctive relief is when you say the landlord is not, the landlord hasn't fixed my stove and I told him about a month ago, and the judge just says, hey, get her a new oven and stove. That would be injunctive relief. Or, the window is busted or the lock on the front door is busted, and the landlord just says, well, fix it. That's injunctive relief. And the next one is called actual damages. And so this is a monetary amount, but it is specifically money that you as the tenant either have to spend or have already spent as a direct result of the problem. So if the problem is so bad, if the place floods and you have to move out, if you have to stay in a hotel, then that could be actual damages. If you meet all the other legal requirements, the court may give you actual damages and pay you back for the money you spent in a hotel. Also, if the problem was so bad that you had to pay a repair person, a plumber, contractor, if you had to pay them yourself, that could also be actual damages because you had to spend your own money to take care of a problem that the landlord knew about and the landlord had an obligation to fix. The third one is attorney's fees. And this has a special requirement, but attorney's fees means if you hired an attorney to represent you taking the landlord to court, the landlord might be stuck with paying for your attorney. But that's only in specific circumstances, as you can see here. The only circumstances are when the landlord is intentionally trying to avoid obligations. So basically, you could always say, like, they're just avoiding fixing it. Like whenever, it doesn't matter how busy they are, you can always use that if you wanted to. So this has kind of, if you can prove that the situation is more serious, like if it generates more of an idea of just this landlord's really slacking, like they could have done something about this a while ago, but they chose not to do it. That's the kind of thing, that's the kind of threshold, that's the kind of standard you're going to have to meet in order for the judge to tell the landlord to pay for your attorney. So those are the benefits. Those are why someone might take someone to court, but why, if you can get those things, if you can have the judge demand your landlord fix it or get you money and even pay for your attorney possibly, why doesn't anyone do this all the time? Why even worry about a second option? Well, it takes money to file cases. There is a filing fee, and not only that, but you have to pay for it to be served as well. So you do have to start off with expenses yourself. And that's just expenses to get the process started. That doesn't include, if you do hire an attorney, what those legal fees might be. And after all of that, after you file and everything, you may lose. So then you would just pay that money for nothing. And there's also, any lawsuit is going to be a long and complicated process. It is typically going to be very stressful, and it could drag out for months before you get any kind of resolution. And lastly, it requires you proving each one of your claims. And so a claim is a bunch of different things in court. A claim could be, if you say that your stove is broken, you're going to need to prove that the stove was broken. If you claim that the landlord knew about it for a month, you're going to have to prove that somehow. And that's why I recommend getting things in writing. If you say that you had to spend $500 to get a new stove yourself, you're going to have to prove that you spent $500. If you paid your brother-in-law to fix the wall for you, you need to prove that you paid however much you said you paid. So when you take it to court, you are going to have to collect a lot of evidence and a lot of paperwork in order to justify your claim and in order to prove to the judge that the situation is the way you said it is, because that's ultimately what the judge has to decide. Whose story is the right one here? And so you're going to have to bear the burden of providing evidence that your claims are true. So option 2 then, if that stuff sounds difficult, which it more than likely will be, and if that's not how you want to spend your time, you can break your lease and move out. So like I said, you can take the landlord to court whenever, but you can only break your lease and move out under certain circumstances. So you can only break your lease and move out when the problem seriously affects your health and safety or the physical condition of the property, like I mentioned earlier, like those 2 standards. And examples of these are a toilet doesn't work. The health and safety could mean the front door lock doesn't work. If anybody can enter your home at any point, that is not safe. And so that is a serious condition. Also sewage leaks and things like defective wiring. And these are just examples from cases. There are a million different ones. And I know that it's probably tempting to ask, like, well, what about my situation? I have X that isn't working and my landlord said Y. But for any of those kinds of specifics, that's just what you're going to have to talk to an attorney for your circumstances. There could be an infinite number of problems, but this presentation is just supposed to be general information. So if this is only available under when the problem seriously affects health and safety or the physical condition of the property, what's the benefit? What do you get what do you get by choosing this option? So if you follow the legal requirements and you go through that, you provide notice, you wait the amount of time, when you choose to break the lease and move out, you get to move out with no penalty for breaking the lease. And so the penalties can be everything from, like, the harshest are you have to pay the rest of if you got a lease for a year and you only stay 2 months, well, you still got to provide 10 months worth of rent. Or you could be forced to, like, you have to find someone to sublease your apartment, or the penalty could just be like, okay, well, you have to give up your security deposit, which we'll go into more detail in a minute. But the benefit of doing this is you get to leave without having to worry about any of the penalties for breaking a lease. And that's really it. Like, you just can decide this problem is so bad that I don't want to deal with it anymore, and I don't want to deal with the landlord anymore, so I'm just going to move out. And if you follow the legal requirements, you are able to move out without getting any penalties. So when you move out, though, I want to make sure that some things are clear. When you move out, you want to take lots of pictures, first of all. You want to take pictures of any of the damage, like especially the repair problem that you had, and you want to be able to take pictures that show that any damage that was there was not caused by you, it was caused by the problem, or it was there when you got there. So you want to take lots of pictures so you can be able to say, there's no reason why I shouldn't get my security deposit back, and I don't owe you anything because all of this is essentially what you could have fixed yourself. And to that end, like, you want to send your landlord. I know a lot of people who have said they just want to cut all ties and they don't want to ever hear from their landlord again. Well, I mean, that's fair and that's understandable, but you do want your landlord to be able to send you your security deposit. And I think it's a good idea to say, I'm giving you my forwarding address to get my security deposit, because you want to draw attention to that security deposit. You want to let the landlord know you have not forgotten it. Because if a landlord does not return the security deposit like it says in the lease, and you can take them to court for that. If they say, if you, like for instance, if there's a leaking pipe and that's the reason you leave, and you went through all the legal requirements, they can say, well, we had to use your security deposit to pay for the leaking pipe. No, that was what they should have fixed earlier. You deserve your security deposit as in the lease. If there are issues like nail holes in the wall, then yeah, the security deposit should cover that. Or if the carpet needs to be replaced because the dogs tore it up, yeah, the security deposit should cover that. But if it's not your fault, and particularly if it's because of the repair issue, you can take the landlord to court, and depending on just the circumstances again, the judge may award you with 3 times the amount that was improperly withheld if you win. So if you have to pay $650 the first month's rent as a security deposit, then you would get 3 times $650, or you could if you win that case. So those are the benefits. Those are what you get from breaking your lease and moving out. So what's the process look like then? So let's go into more detail about what it means to take your landlord to court. So if you think this is an option, whatever your situation is right this minute, start gathering evidence now. You want to go ahead and be able to document everything. Like I said, one of the difficulties about taking your landlord to court is just you're going to have to prove everything that you're claiming. And so pictures and videos work very well. If you use pictures, take lots of them and print them out. You want to be able to hand copies over to the judge when it comes time for the hearing. So for other things that don't show up as well as in pictures, like I included the examples of flickering lights or leaking pipes, things like that. Videos are going to work better because that way you can, show that the lights aren't working and things like that. But if you do that, like everybody's got a phone, it seems like nowadays, or most everybody does. And almost every phone I've seen in recent years always have a camera and video capacity, but you can't, or you don't want to hand your phone over to the judge when it comes time for the hearing. So what you want to be able to do is, even if you take a video on your phone, either save it in a format, email it to yourself, you'll need to find a way to burn a copy of it onto a DVD. And so you can also use like a thumb drive, but I think at least for now, with the way technologies are and the way courts, advance with the times, it's a safer bet to burn everything onto a DVD so that you can hand them a copy of it and say, Your Honor, this is the video of the panel, the electrical panel sparking or the pipes dripping. Just you want to be able to hand it over to the judge, and you don't want to have to hand the judge your phone and tell them just, okay, swipe until you start, seeing pictures of the damaged house. So including things like gathering your own evidence, you may also want to call code enforcement or a building inspector. Like you can call someone whose job it is to examine whether things are put together the way they're supposed to be, and you can have them write a report for you. You can use them and their services to kind of help make your case. And to that end, you want to, as part of the evidence, as a significant, typically big part of the evidence, you want to talk to any witnesses who may testify on your behalf. So that could be, your spouse who also lives there, who knows that the lights flicker every time you turn on the light over the sink. Or it could even be one of the person who did the code enforcement or the building inspection. You can even get them. You can have them testify and say like, yep, when I was there, I saw this kind of damage and it looked like it had been there for this long. Or, I told the landlord about this 6 months ago and here I am back again. So be prepared to talk to anybody who is, like an adult. Like you don't want to put your kid on the stand, your 6-year-old on the stand, but be willing to bring anybody who might be willing to testify as a witness on your behalf. So start gathering that evidence now. Go ahead and start talking to people. Go ahead and start taking pictures. Don't wait until after you have filed for the action before doing these things, because you want to be able to go back as far as you can, with as thorough as you can, to show that this problem's been there for a while. So after you give your landlord notice and wait the appropriate amount of time, after you meet those legal requirements, you can gather your evidence before you do those things. There's nothing stopping you from taking pictures in your own house, but after you follow the legal requirements, you give them notice and you wait the appropriate amount of time, you can file your action. So what to file? It's basically just the collection of paperwork that you're going to need to bring with you. And I want to take this opportunity to draw your attention to a website that we have. So this is learnthelaw.org/group, and I'm going to have the address at the end because this is a phenomenal resource. So first of all, I just want to show you, this is just a classroom that's on the same topic. Like this goes and probably does a better job than me explaining what you can do and what your options are. But it also has these amazing online tools. So if you aren't comfortable because you don't feel confident in how well you can express yourself on paper, then let this do it for you. Here is an online tool to create a letter notifying your landlord that repairs are needed. And so you can just click this link and that takes you to this other website, and you can click get started. You can complete your forms and print them out. And so after you get started, it's going to ask you for this terms of use. Just click you agree and then continue. And then you are in this, you're basically having this conversation with this website who's going to help you fill out this form. So you can just answer the questions and fill out this simple information, and it can spit you out the form that you need signed. So I wanted to point that out for one. That's one tool that we have. And another tool that we have, so this is to help write a letter notifying the landlord that you need repair. So this is one of those legal requirements. But if you want to take your landlord to court, you can skip all these and go down to follow through, taking your landlord to court. And there is another online tool that you can use. So you can just click on this link and it will help you collect all the paperwork that you will need. And if you need to find out which court that you're filing it at, then there's a list. You can find the contact information for your local magistrate courts here. So, like I said, this website has got some phenomenal resources. I can't recommend it enough. It's got online tools that allow you to advocate for yourself, and it's quite amazing. So I'll have the link up at the end, like I said, but I just wanted to take a moment and highlight this was just 30 seconds of the resources available on this website. It's amazing. I love it. So after you follow the legal requirements, what do you need to file? What are the documents that you need to take to court? So so I recommend using our online tool, like I just said. It can help you out tremendously. It can take away a lot of the work for you. But if you're not using that, you need to file what's called a complaint, and you need to bring the filing fee. And so I have 85 plus 10. We looked it up, and the filing fee is $85, but you also have to pay $10 for serving it on the landlord, which I'll get to in a second. And as far as the fee goes, you can request that the court waive the fee. And you can just say, basically, you can fill out this application that basically says, I can't afford this fee. Like, I have this serious problem, this justice issue, but I can't afford the filing fee, and the court may agree to waive it for you, but they may not. You need to be prepared with $85 when you file, because they may not accept your application. They may expect you to file the fee anyway. So that's what you need to bring with you. You need to bring a complaint, and you need to bring the filing fee. And you can get a copy of a blank complaint. You can visit the court and ask them, and they'll be able to provide you with that document. So let's say you have all your paperwork, gotten all those ducks in a row, shuffled all those papers. So what do you do next? Where to file it? So you need to file it in the court of the county where the property is. So the court, it could be magistrate or circuit. I'll get to that in a second. And it needs to be in the county where the rental is. It doesn't matter where the landlord lives. It doesn't matter where the property manager lives or where the property manager's home office is. What matters is the unit where you live, the unit where the repair problems are. That's the county that you need to file this action, this lawsuit in. So if you think the damage will cost less than $7,500, you can file it in the magistrate court of the county where the property is. And if you can get that estimate from a lot of different things, like if a contractor says this is how much it's going to cost to fix, or if you were like, I had to spend 6 months in a hotel paying $100 a night. So whatever the case may be, if you believe that it is worth more than $7,500 or less than $7,500, it can be filed in the magistrate court. But if you think it will cost more than $7,500, you'll need to file it in the circuit court. And the circuit court is a lot more difficult and a lot more complicated. And they are less forgiving for people representing themselves in circuit court. So if you believe that your case is worth more than $7,500, I recommend you find a private attorney to file it on your behalf, because that's a lot of money to deal with and to try to recover, and the process just gets way, way, way more difficult and complicated going from magistrate court to circuit court. So after you file it, the landlord needs to be served. And so this is frequently done by the sheriff of the place of the county where it's filed. And like I said, there's a $10 filing fee. But if the landlord or the property owner does not live in that county, then you may need to go to, you may need to do it yourself, which basically just means you can't do it yourself, like hand it over yourself, knock on their door yourself. You can't do that. But you can get a sheriff to the sheriff of the county they live in and have them do it, or you can get a private company called a process server to do it for you. So those organizations can serve, and they serve people all the time. So after it's served, you just got to wait. The landlord has 30 days to make a response. And the response could be, yeah, you're right, I'm sorry, here's the money. The response could be, you're lying through your teeth, I'm going to fight this to the bitter end. Or they cannot respond. If they don't respond, then you will almost definitely win your case by what's called default, meaning just the other party didn't show up to defend themselves. So they have 30 days to respond after being served without losing by default. So you just have to wait for them to respond and for them to put in their answer. And after they put in their answer, maybe even before, if you know it's getting down to the end of the 30 days, the court may go ahead and schedule a hearing. So a hearing is just it's basically another word for a trial. There's not going to be witnesses. There's not going to be a crowd of people. Like, this isn't going to be what you see on like Perry Mason or any of the crime dramas, Law and Order. This is going to be typically a much smaller deal. And this is where you make your case to the judge, and by the end of the hearing, the judge will say whether they found in your favor or whether they found in the landlord's favor. So at the end of the hearing, that should be when it's completed, when you are given one of those three ways, those three benefits: the injunctive relief, actual damages, and or attorney's fees at the end of the hearing. And so the hearing is where you bring all the evidence you gathered. That's where you're going to make your case. That's where you're going to present your arguments. That's where you're going to call your witnesses, hand over your DVDs and stacks of pictures. The hearing is where all that stuff happens. So you're going to have to, when the hearing is scheduled, you're going to have to get everything together, including your witnesses, tell them when it is, and present your case to the judge. And like I said, at this point, after the hearing, that should be when everything's completed. That should be when the judge finds in your favor or finds in the landlord's favor. But one way or the other, it's probably going to be finished at the end of the hearing. So if you're not taking your landlord to court, but you're choosing to move out, what's the process for that like? Well, after you follow the legal requirements, you're done. There is no real process. You just gotta move out. You said in the notice you're going to wait 14 days. If it's not fixed in 14 days, then you have no more obligations. You can move out. You can sign a new lease someplace else. You can move in with a friend. You just don't have to be there anymore as long as after you have completed those legal requirements. Free to move out. You're like I said, you're done. But I want to make sure that you move out in the same way that you would under better circumstances. So, let's say you lived at a place for 2 years and you really love the landlord, but you got a job in a different city, so you got to move out. You got to treat the situation the same way. You don't want to burn any bridges. You don't want to cause any damage to the property. You don't want to behave in a way that may come back to bite you later. So first of all, you are not moved out until all of your property is gone and you have given your keys back to the landlord. So if you leave but still have the keys with you, then the landlord can say you haven't moved out yet and you could still be responsible for rent or any other obligations. And the landlord can still deduct from your security deposit any damages that you caused to the rental unit. So just like ending any other lease, if you tore the drapes, then your security deposit may pay for the drapes. If your dog ripped up the carpet, your security deposit will have to cover new carpet, things like that. So the landlord still can do those things because that's what you sign in your lease. But other than that, you are free to leave. So that's the process for the two options we've talked about. But there is a burning question that I get all the time, and I'm sure most, if not all of you, have been thinking it this entire time. So if my landlord refuses to fix the problem, can I stop paying rent? That is a very common question, and it makes sense that you should ask that because that seems like a logical choice to make. My rent is what I'm bringing to the situation, to this contract, and the landlord's supposed to be bringing repairs. So if he doesn't do his side, I don't have to do my side, right? If my landlord refuses to repair the problem, can I stop paying rent? Yes, but it's a bad idea. You legally can, but under very specific circumstances, and it's very difficult to do this correctly. So people ask me that, and this is my answer. Yes, you can stop paying your rent, but it is a bad idea. So that is the last resort that I brought up in my overview. Not paying your rent should be if, for whatever reason, none of the other options are available to you. And what I mean when people ask, can I stop paying my rent? And I say yes, what that means more specifically is if you are being evicted for non-payment of rent, you can use the repair problems as a defense. So if the stove is broken and you say, I'm not going to pay rent anymore until the stove is fixed, and then 2 months go by and the landlord's like, well, I'm going to evict you because you haven't been paying rent, and takes you to court, that is when you can use it as a defense. So that's what it means. If the landlord tries to evict you for non-payment of rent, you can use the repair problems as a defense. So there are specific reasons why I think this is a bad idea and why I think it's more than likely not going to work out in your favor if you try it. And these are the reasons why it should be a last resort. First of all, you have to wait for the landlord to file an eviction for non-payment of rent, so you're not in control. If the landlord, for whatever reason, the landlord could let you live for 6 months without fixing the stove. It just depends on what the landlord's comfortable with and how long they're willing to accept not paying rent. So you are not in control of the process at that point, the same way you would be if you had said in 14 days, I'm going to move out or sue you. Then at the end of those 14 days, you're at the helm suing them. You choose that timeline for that. You keep going with that process. And the same thing for moving out. You can decide when you leave because you're done. But if this is the choice you're making, you do not have control over the timeline or over the process. So that's the first reason. The second reason is there are several reasons. Yeah. So the second reason that this is a bad idea is that there are several reasons why the landlord might evict you, might evict anybody. And only one of them counts for this. So if you're on a month-to-month lease because your written contract expired a year ago, if they say, okay, well then I'm just not, at the end of this 30 days, I'm just not renewing. Your lease is over, so at the end of the month, just move. Well, if that's how they chose to do it, then you don't have the defense because they did not evict you for non-payment of rent. They evicted you for the end of the lease. Or if there's another lease violation. So if the landlord's like, okay, well, someone else has been living there and they weren't on the lease, so I'm finally, I've been ignoring it up until now, but now I'm going to evict you because you've been violating the lease, or because you didn't pay the pet policy and I haven't cared about the cat. But if they start wanting to hold you accountable for that, they can, and they can choose to evict you for another lease violation. And if they do any of those, then your repair problems will not help you. You can tell the judge, but he didn't fix my stove, and the judge will say that's no reason why you let someone live there who was not on the lease. So it's a bad idea because they don't have to evict you for non-payment. They could evict you for other reasons, and you're gambling that that's the reason why they're going to evict you if you choose to withhold your rent. And let's say they do it. Let's say you call their bluff and you guessed correctly and they did choose to try to evict you for non-payment of rent. Well, even if they do that, evictions move very quickly, especially for non-payment of rent, and it is very easy to forget or miss a deadline. And if you forget or miss any of those deadlines, and if it just zooms past you and you drop the ball, well, then your repair problems aren't going to help you. Like I said earlier, if you don't show up, you lose by default. So even if you have a defense, like the repair problems, if the situation gets away from you and you just forget about the hearing, or you misplaced where the documents were that said when the hearing was, that kind of thing, if it gets away from you, then your repair problems aren't going to help. And lastly, the last reason why I think this is a bad idea is for this to work, for this plan to work, you are going to need to be able to prove to the judge that the landlord knew about the problem at least 14 days ahead of your missed payment. So if you're saying, like, if you tell the judge, like, I've been withholding rent because of this repair problem, the judge will ask, how do you know the landlord knew about the problem? And it's going to be up to you to prove it. You're going to bear that burden. So if you can't prove that the landlord knew at least 14 days, then your defense is not going to work, most likely. So that's when it comes to, you have the same, it's just a better idea all around to try to use one of those other options. Because this one, if you try to use this, there are just so many opportunities for it to go poorly for you. So like I said at the beginning, what I wanted to do with this presentation is tell you what your rights and options are. So your two options are to take your landlord to court or to move out and break your lease. And you can do those after you have met the legal requirements. And the very last resort is withholding rent, withholding rent until they repair it. But I believe that is a bad idea. And so also, like I said, I told you there would be, I told you I would put up the link. So up here at the top, you can see that's the online resource. I want to give you a minute to write it down, and this video is going to be posted to YouTube where you can pull this up and pause it. But I just want to make sure that everyone has an opportunity to write that link down, because I went through one topic of getting your landlord to make repairs, but there are a dozen topics all over the place. South Carolina Legal Services handles things in family law and probate law, all kinds, education, all kinds of different areas. And so that website's going to have a broad variety of topics. So that's the link, learnthelaw.org/group/502/class, and the classroom and 2249 that's for the stuff specific to repairs. And then I wanted to just give you this opportunity to have access to the Landlord Tenant Act. It's printed, it's 100% of it's online, it's public. So if you go to this website, www.statehouse.gov/code/T27C040.php, it's complicated, but if you go to that link, that will pull up the South Carolina Landlord Tenant Act. And I thank you all so much for your time. Those are your options for how to get landlords to make repairs.
Okay, Arthur, well, we do have a few questions from our audience if we've got a little bit of time left to answer those.
Yeah.
So first, what is a reasonable time frame for landlords to fix the heat? Can you make a request that they tell you when they're entering your apartment? And I guess that's really two questions.
Okay, so let me tackle the first one first. So like I said, any kind of repair problem is going to be very specific. So it makes the difference if the heat is not working at all, just totally, dies on you in the middle of January. That's going to be a different set of circumstances than the heat just doesn't work all that great in March. So it depends on how badly it's not working and when it is and what the other circumstances are. It could even make a difference if you have one of the tenants is 90 years old and just doesn't handle the cold very well. So all of those can make a difference. So if it's mild, then it may qualify as like the 30 days reasonable amount of time. But if it's serious, like if it's January and the heat is not working at all, well, that affects health and safety. So that could very likely be one of those serious situations where they have to have it fixed in 14 days. So like I said, it just totally depends on the specific circumstances about whether or not it seriously affects health and safety or not. So that's something that I can't answer for you about your specific circumstances. You're gonna have to talk to a private attorney for. And as far as accessing the house, or accessing the property, the landlord can access the property to make repairs if it's done at a reasonable time. So like between 9 a.m. and 5 p.m., things like that within business hours, or if they give you 24 hours notice. And so if they let you know ahead of time that they're coming, or if it's to fix something you've already agreed on, like if you know your landlord's already talked about it and your landlord says, okay, I'll be by this week to fix it. If it's something you've already agreed, if it's a repair problem that you already have agreed to have them fixed, then at that point they just have to come within business hours. But it's a courtesy. More often than not, you can request that they give you 24 hours notice before they try to access your property. So hopefully that helps. Are there any other questions, Susie?
Got another one. What if there is mildew or what looks to be mildew because it's a black color, and you need it washed off of the house, and you've tried yourself to remove it and that hasn't worked? Things, I guess, on the outside of a house that are like that, is that handled in the same way as what you've been talking about?
Oh, well, so yes, that is a repair or maintenance issue, because that's an issue with the property that needs to be addressed. So in that sense, yeah, it is. It applies to everything else. Just like if your mailbox got broken, that would apply too, because that's a maintenance or damage issue. So it is a question of like I don't work on homes. I don't know exactly what mold or mildew can do to the side of a house, but it sounds like it could be a problem for the condition of the property, if nothing else. Like I know that it's gonna hurt the resale value if people are looking at mold. But also, I mean, I don't know I think there's a little bit of a gray area about, since the issue is outside. If it were inside, no question, it would be a serious health problem. No question about it, because that's a common one. Like black mold is dangerous to be around, and so if it's inside, it's pretty clear. It's almost always going to be one of those serious health problems. But if it's outside, I'm not sure that it will be treated the same way, because you just aren't. It's not enclosed. It's open to the air, so you don't have to. You're not going to be breathing as much in. So I'm not sure that it being outside is going to make it a serious health problem, but it sounds like it might be, sounds like it might qualify as a problem that seriously affects the condition of the property. I haven't seen it. I don't know. So I think it might be one of those two, but I'm not sure. That's, like I said, all these repair issues are very specific. So I would recommend talking to a personal attorney about your specific circumstances.
Okay, here's another question. Does the landlord need to keep the property up to the current fire code? In other words, things like smoke alarm, fire extinguisher, window size, and so forth.
It's been a while since I had that issue come up, but so I know that they do not need to, if like the code changes, they do not need to change the property with it. But if there is an issue that, like for instance, if the place burns down, or if they need to replace the window because you know, a baseball goes through it, if they replace it, then they would have to replace it up to code. So and that's as good as I can remember. I'm pretty confident that's the case, but I would strongly recommend talking to an attorney about your circumstances specifically.
Okay. And one other question is wondering, do these websites have a Spanish translation? And actually, I think I can answer that. On learnthelaw.org, those classrooms do not yet have a Spanish translation, but that is something that is in progress. So they will have Spanish translation in the future. They are just not live on there right now. And there's one final question that one of our audience members has, and that is, what if the units or apartments, I guess, have dryers and the venting system is faulty? How long do you have to repair the venting?
Again, I can tell you that if for appliances generally, if it was there when you moved in, then the landlord has a responsibility over it. But if you brought it with you, like if the unit did not come with a washer and dryer and you brought your own washer and dryer, then those problems would be on you. But if you move into a place that already has a fridge and the fridge goes out, then that's on the landlord. Now, the venting system, it depends. Again, it depends on what exactly it's doing, because I've heard of some cases where it doesn't go all the way into the wall, so it just empties the exhaust like in the room, and then if it makes the house unbearably hot, then that may be a health and safety issue. If it sounds like, depending on the nature of how it's faulty, it sounds like it might be a fire hazard, maybe. But so again, like I hate to keep harping on about this, but the question about whether it seriously affects health or safety, or whether it seriously affects the condition of the property, or neither, it's always very specific to the circumstances. So that's something that you would want to talk to an attorney about. And anybody with those kinds of repair issues, you can apply to our firm. You may talk to an attorney in legal services who can help answer those questions more directly. So you don't have to necessarily hire a private attorney. You can just apply online and say, I don't know if I have the right to demand a repair for this dryer issue or mildew issue or any of the other things, or even the question about the code. Like, I don't know if I have the right to demand these, and then your case will be reviewed by the closest office to you. So I would absolutely advocate reaching out to us and our firm to see if you can get some help from some personal help from an attorney in the office closest to you. So I'm sorry, that's just the nature of it. I can't be much more specific without it turning into like a, legal advice.
And maybe even someone who knows more about these kind of matters, even more so than the attorney. I'm sure sometimes an attorney's advice is going to be that you've got to get some kind of evidence that is affecting the health and safety. So I think that's a great point to contact your own attorney for some assistance with that. Well, listen, Arthur Hayes, I want to thank you for a terrific presentation on how to get your landlord to make repairs. That was very informative, and I'm sure all of our listeners appreciate it. I want to also thank all of you who joined us today. We really do appreciate your interest in this subject matter and the other subjects that we tackle here on Level Up Law. Remember to join us for Level Up Law every Tuesday at noon, where we educate the public on some of the most common legal issues we see here at South Carolina Legal Services, and this subject today was certainly one of those. Now, all of these free webcasts can be found on our YouTube channel under the Level Up Law playlist. So you can go there and find all the ones we've done before the one today. And if you found this one helpful, go there and please like the video and share the broadcast with others that you know it might be useful to. That always helps us get the information to more people that might not know about the series or might not know about this subject matter. If you subscribe to our YouTube channel and sign up for those alerts, you'll get a notification each time that we post a new episode. All right, one last thing. As Arthur said, if you have an issue and you need legal assistance and can't afford a lawyer, you may be eligible for our free legal representation, and you can see here on the screen the information, as Arthur mentioned, about how to apply for that assistance. The great staff at our intake office are standing by Monday through Thursday from 9 to 6, so be sure and call that number or apply online to lawhelp.org/SC. And we actually do have, I always like to mention, we have a Level Up Law episode on that YouTube playlist that I just mentioned that actually walks you through tips on how to apply online for our assistance. So if you have any trouble with doing that, you can always go check out that episode for those tips to make sure you get that application in properly. And also just keep an eye on our South Carolina Legal Services Facebook page to see what's coming up, and also follow us on Twitter and Instagram, where we post regularly about this series and other important legal topics. Now, finally, next week, we'll be talking about the ABCs of student loans, so be sure to register and tune in for that great information that will be shared by Tiffany Love of our Columbia office. That's all we have for today. Thanks everyone for tuning in, and we look forward to having you back with us next week on Level Up Law. That concludes today's webinar.